Today's topic is heirship certificate. What is heirship certificate? How you should obtain a heirship certificate? What is the process for heirship certificate? What you achieve by acquiring heirship certificate? All topics are going to be covered in this series. My name is Girish Rao. I am advocate and solicitor, having more than 28 years of experience. And this video is brought to you by Legal Scholar Academy. Legal Scholar Academy conduct various courses in different topics of law, like drafting of agreement, master in drafting of pleading, master in RERA, and various other topics. If you want to know more about it, you can connect with Legal Scholar Academy or the number which is given down here. Then, in addition to that, Legal Scholar Academy also conduct on every Friday a webinar on different topics of law. Those webinars are free of cost. Those who want to attend can also connect with Legal Scholar Academy at the top and the number which is scrolling down over here. So now let's begin our today's topic. Before we begin our today's topic, it's my request to everyone. If you are not already subscribed to this channel, subscribe to this channel so that as and when we load new videos, you will get a notification of it. All videos are on topics of law, which will be very value addition to you. So I will suggest kindly subscribe to this channel. And don't forget also to hit like button. I'm sure you're going to do that because I'm sure you're going to like this video. Okay. Now let's start with our today's topic, that is heirship certificate. What is heirship certificate? Heirship certificate is a certificate which is issued by the court under Bombay Regulation 8 of 1827. It is basically a certificate which court says that a particular person is the legal heir of the deceased. Subsequently, Indian Succession Act 1925 was amended, and many issues regarding inheritance of the property is regulated by that act now. Normally what happens whenever an act is enacted, the earlier act is repealed. But in this case, earlier act is not repealed, but certain sections of Indian Succession Act are deemed to have been part of Bombay Regulation Act. In this section, we are going to restrict ourselves only towards the heirship certificate. So now let's begin. What else does or what is the procedure to know about heirship certificate? First is that who should obtain heirship certificate? If you want a legal recognition as you are a legal heir of a particular person, then you will require a formal recognition from the court that you are the legal heir of the deceased person. For that purpose, you will have to obtain a legal heirship certificate. Often, the banks, government organization demand that you should have a legal heirship certificate. So what is the procedure? So how you should make an application? Application should be made to the district court for issuing heirship certificate. Depending upon which court, what it is addressed as miscellaneous petition, testamentary petition, all courts have different method of naming the application. The application should in brief state about the death of a deceased. You will have to attach a death certificate, relationship with the deceased, on basis of which you claim that you are legal heir of the deceased, law under which you say that you are legal heir of the deceased, and particulars of the movable and immovable property left by this deceased. Why you have to require a particular of the deceased, particular of the property left by the deceased? Because you will have to also court fees to this application. The maximum court fees which has to be paid is 75 lakh in the 75,000 in the state of Maharashtra. Yes, which court the application for issue of heirship certificate should be made? The application for the heirship certificate should be made in the district court. And in case of Mumbai, it should be done in Bombay High Court. Because for Bombay, High Court is a district court. Its original jurisdiction is considered as a district court. What does then court do when application is made? The next question is that the procedure which court follow while issuing a heirship certificate. When you make an application to the court, in that application, either you will have to also tell who could be the other heirs of the deceased or who could claim some objection. So when you make an application to the court, court issues a proclamation. Proclamation basically a public notice is issued in the newspaper, making that disclosing it that a particular person has made an application for declaring himself as a legal heir of this particular deceased. If anyone has any objection to that, should come forward and lodge your objection. That is what basically is the process or the proclamation will contain. That is supposed to be published in the newspaper. Then if no objections are received from any person, in that case, court will go ahead and if satisfied from the contents of the application and also the evidence which is led, issue a certificate of heirship. As stated earlier, we are restricting only heirship certificate under the Bombay Regulation Act. So suppose you want to make opposition, rather you want to oppose the application. In that case, what you should do? If you want to oppose the application, in that case, you will have to file an affidavit opposing the application. That application affidavit has to be filed within 30 days from the publication of the notice. Then when such opposition is filed, what is the court supposed to do? If opposition is filed, then in that case, court should summarily investigate the ground of the objection on one hand and write claim by the applicant on other hand and the evidence or the witness which is produced. See, note that this is to be held summarily. That means court is not going to go in detail. Basically, court is going to accept what you are stating on the affidavit. So that is what court is going to consider when it is considering the opposition to this application. So now you make an application or you make an file an affidavit to oppose the application. Then what is that court is going to see? Or rather, what option the court has? The court will have following option. Number one is that after court considers that there is no substance in opposition, just for sake of opposition, he is opposing. So court will grant a heirship certificate. Second is refuse the heirship certificate. Court may come to conclusion that the applicant is not heir, so may refuse the heirship certificate also. Then, if question is complicated or difficult in nature, suspend the proceeding until question is tried by a regular court instituted by suit by one of the parties. So if court comes to conclusion there is some complication issue or question which cannot be summarily disposed of, then court will suspend the proceeding. Realize that suspend the proceeding so that the applicant has to file a proper suit, or rather any of the party has to file a proper suit for claiming their right. So it will suspend the proceeding till that suit is filed, and on basis of that suit, this application is supposed to be disposed of. Then court may also find that both the person who has made an application and the person who is opposing the application are both legal heir, then court can also issue a legal heir certificate for both the person. There are certain misconception about legal heir certificate. That court, number one is court converts the application to the suit if you file an opposition application or affidavit. Just you file an affidavit, you may have no substance, you may not be legal heir, or you have no claim. Still, you file an affidavit, then it is converted to suit. So that is a misconception what that is there. As I told, court will have to summarily decide it what whether that application has substance. If no substance, then court can grant the heirship certificate. That is. Other number two is misconception is that refusal of the heirship certificate shall finally determine the right of the person whose application is refused. No, that is also another misconception. The person whose application or application is refused, he will be still competent to institute a suit for establishing his right as heir of the legal heir of the deceased person or on the property. Next, a granting of certificate also does not confer any right to the property, but it only indicates that person who has made an application for the heirship certificate is entitled to legally manage the property of deceased. So any person has got something better right, he can annul it by making an application to the district court that he has a better or preferred right than the person who has got the heirship certificate. This was the basic talk. This is a basic understanding which you should have when you are discussing or understanding about heirship certificate. If you have any query about that, you can give a comment on the comment box. We'll certainly get back to you, reply to those comments. And if you want to know more about it, you can also connect with us. We'll be guiding to you on the number which is given here and also the email IDs. Then, if you want to know about the courses conducted by Legal Scholar Academy, also you can connect with the Legal Scholar Academy on the number which is scrolling in now. And again, if you like this, kindly press the like button and also subscribe to this channel. With this, we are ending this today's topic on heirship certificate. I hope you like this topic. And if you have any comment, do kindly post it in the comment. Thank you. Bye-bye. Take care. Bye-bye.